Swayam Prabha. Digital India. Educated India.
Welcome to the course Environmental Impact Assessment. Today we'll cover cultural heritage, like what are the legal aspects to it, and then we'll also look at the health under this, and this will do it in the larger ambit of our discussion on law, policy and institutional arrangement. So since we are covering all these legislation parts, we'll look at these two today. So our coverage would involve, like we'll look into cultural heritage, international heritage conventions, treaties and charters in this direction. And then we'll also look at health, like what's the scenario, what kind of legislation, guidance and standards which are available. So accordingly, our learning outcomes will target that you should be able to identify different cultural heritage, international heritage conventions, treaties and charters. You should be able to name them, list them, identify them, and then learn their purpose, and then you should be able to synthesize what implication it would have on EIA process. Then you should be able to identify health related legislation, guidance and standards, and then look at its implication on EIA process, as well as understand, synthesize the current scenario, how much it has been applied or not applied. So looking at the key legislation related or the guidance or standards related with cultural heritage, we see that cultural heritage is also protected by legislation in nearly all the countries. So most of the countries have legislation for protecting the cultural heritage, and we see those interventions at the international level. We see it that you have treaties, and mostly, like you have been seeing, that most of the common form is the convention, and through that we set legislation and policy framework through which we really translate into the national government level. So from the convention, then we set up legislation policies at the national level so that the global agendas can be translated at the national level. And this is usually done when we ratify the convention. When there's ratification, we take care of that. So some elements of tangible cultural heritage can be protected by legislation, but the other element, like the intangible elements, can be protected by statute, and in some countries land use plan provide protection for cultural heritage assets through land use planning also. So land use planning, the lands are protected for that particular purpose. So we also see that interventions are also undertaken for the purpose of protection of cultural heritage resources, mostly the physical resources, and they are taken, interventions are taken at the national, regional or the local level. And for us it is important to review what country follows, so where all we have ratified, what kind of convention, what kind of rules are there, what kind of resources are there, so that we incorporate those things and consider those things in the EIA process. So looking at the World Bank document and reference, we see that there are four major types of broader type of legislation which are identified, and generally we see them at the national level. So these four types include that you see legislation which are meant for protection of different types of places or any unique particular place, and sets and then there are procedure for their protection. So those kind of legislations are there. Then we also see that there are land management, zoning or planning acts that provide general protection. So you would see there might be under land use, there might be like what kind of zone it is, heritage zone. cultural zone which might be protected under the law. Then you also find acts that require recording of data on cultural sites and listing and all. So you also see where like listing is done under UNESCO and all these. So there can be acts which are just listing it, documenting it. And then you will also find acts that protect natural areas where cultural features may be located. So those areas can be protected. So you see these four types. You see that protection through the process would happen. Then there could be land management or zoning. There can be also listing of the things, and then there can be protection which can be provided to the natural areas. Now looking at the key international conventions, so we're going to list all the conventions, most of them, to see like what kind of international conventions, treaties or charters which are there, which we can see here. So we see that in a chronological order that we find Convention for the Protection of Cultural Property in the event of armed conflict, Hague Convention. So here we see the key purpose of this is to provide a system where the cultural property can be protected, and especially in the situation of international and domestic conflict, if it happens, and they have been ratified by many parties here. So we see that India has ratified to this. Most of the heritage parts India has, most of the heritage convention India has ratified to. Then you also find 1964 International Charter for the Conservation and Restoration of Monuments and Sites, which is also known as Venice Charter. So through this charter there are a set of principles meant for the conservation and restoration of the monuments and sites, and this is mainly, you can see the IICOMOS, where this charter has been provided, and we are also signatory to that. In 1970, you also find Convention on Means of Prohibiting the Illicit Import, Export and Transfer of Ownership of Cultural Property. So the key purpose of this is to prevent the trade in illegally obtained cultural objectives, and it has been also ratified. Then you also see in 1972 Convention concerning the protection of World Cultural and Natural Heritage, World Heritage Convention. So here the key purpose was to establish a system of how to collectively protect the natural and the cultural heritage, which have the significance, universal significance. So we see India is also signatory to that. Then 1992 we see Convention on Biological Diversity. So the purpose of this, this you have already seen so many times. So Convention on Biological Diversity, CBD. So the convention recognizes the cultural value of the biological diversity and its components, and it also makes provision to protect the knowledge and practices of the indigenous and local communities, and especially these people who rely on the conservation and sustainable use of these biological diversity. And it also intends to protect and encourage customary use of biological resources in accordance with the traditional cultural practices. So it protects that. So it has been ratified by 196 state parties, and then India is also signatory to this. So in 1994 we see ICOMOS NARA document on authenticity. So which is the key purpose is to build on and extend the principles set out in the Venice Charter. So we see that we are again signatory of that. Then you also find ICOMOS International Cultural Tourism Charter. The key purpose of this is to engage in cultural tourism for sustainable development, and then it provides key definition of culture and cultural heritage, and it also acknowledges the potential impact of tourism on heritage assets and communities. The other we find Convention on Protection of Underwater Cultural Heritage. So this sets the basic principle how to protect underwater cultural heritage. It provides a detailed state cooperation system and provides widely recognized practice rules for treatment and research for underwater cultural heritage. So you see this is also there, and we are also signatory to that. Then we find in 2003 Convention for Safeguarding of Intangible Cultural Heritage. So this particular convention focuses on safeguarding the how these heritage are used, and then how the representations are done, how the expressions are done, and knowledge and technology that community has or individuals may have. So how they can become a part of the cultural heritage. So the intangible cultural heritage forms the basic component of this convention, and you see that India is also signatory to that. Then you also find in 2008 Quebec Declaration on the Preservation of Spirit of Place. So this particular declaration looks at how the essence or spirit of a place can be protected, and how it can be protected through the tangible and intangible cultural heritage management. So, we see that India is also signatory to this. Then we also find CON guidelines, CON guidelines. So this particular guidelines deals with the how the cultural and environmental and social impact assessment has to be undertaken for any kind of a development work, and what kind of impact it may have. So in these one looks at the interaction between the cultural heritage, the social and biodiversity, and how do they interact, and how that integrated approach can be taken. We also find UNESCO CBD joint program on biological and cultural diversity. So that has a declaration where they look at the linkages between culture and biological diversity, and try to find out what kind of services, cultural services, are provided by these ecosystems. We also find there's a concept on cultural keystone species, which are defined as the culturally salient species that shape in major way the cultural identity of the people, and their importance is reflected in the fundamental roles these species play in the diet, materials, medicines, or spiritual practices. So those are also identified. So you can look at some of the examples here in the picture, keystone species which are key to the ecosystem there and to the culture and the lifestyle of the people. We also see that there are certain set of indicators used for identifying the cultural influence of these species. So we look at the intensity, type, and multiplicity of the use, how much it is used in different domain, and what kind of naming terminology is there in the language, and then how it has been translated in narrative, ceremony, symbolism. And then we also look at the memory with which people connect, and to what extent their role can be replaced or substituted. So based on those, the species are identified. So that was about the culture, and then you will see that in EIA process it's not distinctively said, but whenever through those four kinds which you studied, if it falls under that, you have to take care of that land use or in the list. So all those have to be incorporated here. So now moving on to the second part of our talk here. So we are going to look at the legal aspect of health impact assessments. So in many countries, health impact assessment is not part of the legislation at a national or the regional level. So it's not yet the part. of the legal framework, but we see there are exceptions. So, with human health risk assessment, HHRA, so which is related with regulatory guidance, which has to be followed because of the potential exposure of human to the chemical contaminations. So, for that, though health is not taken care of, but this particular human health risk assessment, because of the exposure to the chemical contaminant, for that it's usually done and strictly followed in many of the legislation. And for health, when we just talk about health, there are some countries which have been implementing it, but the implementation and that varies a lot. So, you can see in Mongolia has adopted the legislation to include health as part of the EIA process. Then you can also see Thailand, Korea, Ghana, and or even or some of the Australian cities have also incorporated health in their legislative framework. So, by legal, there's a legal requirement to include health impact assessment in the EIA process. So, in these cases, health impact assessment is usually tool mainly wherever these have been implied. They are implied only for the large development project that are anticipated to result in extensive changes to the biophysical and social environment, and they have potential impact, and there are likely changes to health because of those kind of activities which will be taken under through this development project. So, we see that in most of this scenario, the cases which you saw, HIA was health impact assessment was added like into the existing environmental impact assessment legislation. So, there was no separate legislation which came, but then it was included in that. You see that in United States, the NEPA legislation also states that health impact assessment is required. So, we see that the changes are happening, there is more emphasis being given on the health impact assessment, but it is still not very strong in terms of legislative provisions which are given for health impact assessment in the EIA process. So, further we see that there are still since it is not required by the legislation, but it is much required by the lending institutions which give money for the development project. So, for example, like you have been seeing, the International Finance Corporation IFC also requires that health impact assessment be undertaken. African Development Bank also require, ADB also require, Asian Development Bank, Asia Development Bank also require, Inter-American Development Bank also requires that project which receive their funding have to undertake EIA. So, in there particularly IFC performance standard 4, you see that community health, safety and security is given importance, and then it is given the guidelines are given that it is required that the anticipated or projected negative impact on health has to be reduced. And also there is need for safeguarding the health of the people. So, you find all those provisions in this IFC performance standard. Then there are certain guidance which have been issued. So, you see International Finance Corporation also produced a document for impact assessment, Introduction to Health Impact Assessment. So, you can refer to this document also. It gives you certain complete framework how to undertake it. So, the document is intended for the governmental agencies, project proponents. So, government can also refer this, and the people who are preparing EIA or the proponents of the projects can also refer this for their purpose of preparing health impact assessment and also aligning with the EIA. So, this particular guidance gives technical guidance for both the process and the content of health impact assessment. And we see that the specific emphasis is given on like what types of issues have to be taken care of in these areas. Further, we see that there are also emphasis like why it is important to undertake health impact assessment. There are other drivers which like people, because of which the proponents of the project also take a health impact assessment, is like there are a lot of multinational industry corporation which have internal requirement for their own project safety and cost. They have internal requirement to conduct health impact assessments, so for that they take care of it. For example, you can see Chevron incorporates environmental, social and health impact assessments in planning and implementation of its capital projects. So it does it to like identify and assess and manage all kind of significant impact of the project on the health. So that is taken care of. And then you also find other companies, industries, agencies which take care of it, like Shell, Exxon Mobil, Barrick and Rio Tinto, and all these have their internal requirement to undertake EIA. So as a professional, you would like to learn about it so that you know how to undertake it and be familiar about all the legal process which are there or the guidelines which are available for the purpose. Further, we see that there's a lot of business value which is seen by many of the companies. So they have been encouraging this. So we find International Council on Mining and Metals also provide guidance. Then we also see International Petroleum Industry Environmental Conservation Association also provides guidance document for how to undertake health impact assessment. So International Council on Mining and Metal frames the business case for health impact assessment. Like it says that if you identify or maximize the positive community health and well-being, then it has a very positive impact. The project has positive impact, and it also avoids the later cost and delays in the project. So we also see that there are other concerns also why people learn and take up the health impact assessment, is that the project proponents want to be pre-planned, and they want to know what kind of problems may arise. So they are well prepared for the situation, and that might reduce their later cost. So we see that there are other guidebooks also which are available for like how to undertake health impact assessment. So one is IFC, which you have seen. Then there's also industry organizations such as ICMM. Then you also see IPIECA, which also provides. Then you also have several books which are available. You also have practice standards, and all these documents provide how to undertake health impact assessment. So that was about the culture and health we saw today. So summarizing, we looked at different international heritage convention, treaties and charters which many of them India is signatory, so which would be applied, and you also saw the range of legislations which are there, which are applied to this. And then we looked at the health impact assessments and what are the key legislation and guidance and standards which are available for your reference. So this was part of the legislation part. We'll be covering more and looking at the process when we do the methods part. So this was the key reference we have specifically for reading purpose. You can read 2 chapters from this particular book for guidance here. Our coverage was limited, so you can look at further readings and videos you can watch for better understanding. So please feel free to ask questions. Let us know about any concerns you have. Do share your opinions, experiences and suggestions. Looking forward to interacting and co-learning with you while exploring EIA. Thank you.